what we're talking about today is going to be public policy and waivers. And this unusual time that we're finding ourselves in now goes right to the heart of what we call public policy, and I'll explain that. You see right now the government is taking steps to do things that they believe are in the best interest of the public as a whole. They are taking steps that are closing down places where we eat, closing down restaurants, closing down bars, closing down places where people congregate of 50 or more. This is what's being done. They are taking steps to tell private industry that they should also do the same thing, that they should not have their workers coming to work unless they are essential workers. They're telling the government workers that they're not to come to work unless they are essential. In the end, the only thing that's going to be open are the most basic of needs, and that's going to be gas stations and grocery stores and takeout restaurants. That's all that's going to be going on and working consistently. So this particular subject matter comes in at a time that it actually is going on in this country. And you're going to get an exam on this probably later in the week. I'd say about probably Sunday. I'll send it Sunday. It's going to be due by Monday at a certain time. And it's going to be more of an essay format. It's not going to be multiple choice. And you'll see it when you get it, but it should be something that requires you to do a little thinking in your answers. And as I've said previously before, a lot of times there are no right and wrong answers. There are answers that are better than the others, but it's how you explain what it is that you are saying in your answer, how well you explain it, that is the key to what's going on here. So let's just get right to it, because I don't want this video to be too long. I am going to be uploading this to YouTube. So public policy, waivers and releases. We're covering both of those things essentially together. All right, so what is public policy? There's several definitions here, and I'll tell you the one that you're just going to be responsible for. You don't have to know them all. Public policy is a course of action adopted and pursued by a government. A course of action adopted and pursued by a government. So you can see that's going on right now. Right now, there's a course of action that is taking place that is being adopted, certain rules and regulations and requirements, okay, and it's pursued by a government. Pursued could be another word, implemented by a government, all right? And the reason the government can do this is because the government, in the end, has the final say over what all of us do, okay? And that's the interesting thing about public policy. It relates to all of the people, not just a small amount of people. Public policy, when it's initiated, can only concern many people. It cannot, you will not find public policy being implemented for a small group of people. All right, here's another definition. Public policy is a purposeful and consistent course of action produced as a response to a perceived problem of a constituency, formulated by a specific political process and adopted, implemented, and enforced by a public agency, generally the courts, okay? So let's just break that down. Public policy is a purposeful, that means it's not a mistake, it's being done proactively, right? And consistent, right? Course of action produced as a response. It's a response to a perceived problem, okay? So the government right now is taking on certain purposeful and consistent courses of actions in response to a perceived problem. Actually, this problem is no longer perceived, it is actual. This virus is actual, okay? Formulated by a specific political process, i.e. the government, okay? And adopted and implemented and enforced by a public agency, right? So the government in the end has the right to enforce these policies and procedures that it is putting in place, okay? And in the end, if there's a violation of them, people could be arrested, people could be fined, and those arrests and fines would be enforced by the court system eventually, right? So this is it's a complicated definition, but if you tie it to what's going on now, it makes perfect sense. Ooh. Hold up. Sorry about that. Black's Law Dictionary defines public policy this way: is that general and well-settled public opinion relating to man's plain, palpable duty to his fellow man. Okay? So again, general and well-settled public opinion relating to man's palpable duty to his fellow man. What they're saying is that public policy is designed for the good of the people, all right? And it arises out of a sense of the general public opinion that people have to be taken care of, and we are working for the good of others. So generally, an act that concerns much of the public, all right? This what's going on right now concerns much of the public, all right? And is not in the best interests of the public as a whole, would be considered against public policy, right? So an act that concerns much of the public and is not in the best interest of the public as whole would be considered against public policy. So this is another way of twisting this definition, but I'll tell you the one that you're going to be responsible for is the first and the second one on the previous page. So how does this relate to waivers? So a waiver or a release, okay, is the intentional and voluntary act of relinquishing something such as a known right to sue a person, educational institution, or an organization for an injury, right? So how does this apply now and even at this university? Well, several times there's athletes that come to this university to participate in sports and other types of activities at this university. When you come to the university as a student, there's a waiver that you sign. You may not remember it. The athletes sign a waiver. What it essentially says is that the university is not going to be held liable for certain negligent acts that may befall you, all right? They're letting you know, again, a waiver or release is the intentional and voluntary act of relinquishing something such as a known right to sue a person, educational institution, or organization for an injury. So for the athletes, for example, if they get injured throughout the course of their sports, a game, they are giving up the right to sue the university. And what do they get in return for it? Well, they're getting the right to actually come here to St. John's University and play for a Big Ten school. That's what they get out of it. What they give up is the right to sue for certain acts that may befall them, resulting in an injury, okay? A waiver refers to a document because that's how it comes about. There's documents that you sign, and it refers to a document that is signed before any damages or injuries, okay, occur, right? So when you sit down, you come to the university, they indicate that you're going to be a student here, this is where you're going to be situated, this is your dorm room. Okay, they're going to give you some documents to sign, right? And this might be day one. And you sign all these documents, nothing's happened to you. You are fine, you're in good health, but you've actually signed one of the documents, you probably don't remember, is a waiver that says, again, the university is not responsible for any injuries that you will sustain while you're on the university campus. So a waiver is important because it's a document that is signed before any damages occur. A release, on the other hand, okay, refers to a document that is signed or executed after an injury has occurred. You might see a release come up in a situation whereby if someone is in a car accident, for example, and they are, maybe they're rear-ended by a car, they have, they claim to have neck injuries or back injury, and they're examined by a doctor. It turns out they have some sort of whiplash, and they sue for a particular amount of money. Say they sue for $25,000, and they end up settling for $15,000. when that company, when that law firm gives them the check for $15,000, they're also going to give them a document to sign. That document is a release, okay? It is a release. And what it is essentially saying is that you agree that what you're being paid now, okay, is the full amount for all the injuries that you're holding the driver responsible for, and you are releasing them from any further liability should, in the future, it turn out that your injuries are actually worse, okay? So before you sign a release, obviously, you should make sure that from a medical perspective, you have gotten everything checked out and you find out that you are in good condition. Otherwise, signing a release might preclude you from being able to go after that person later if it turns out that your injuries are more severe. So again, a waiver is signed before any injuries occur. A release is signed after an injury has occurred. Couple examples. So, is there a problem with an automobile manufacturer requiring purchasers of all vehicles to sign a waiver releasing them from all responsibility for the negligent construction of their motor vehicle? So that's saying if you went in to buy your car, wherever you buy, whatever car, kind of car you buy, at the time you sign it, time you buy the car, you're asked to sign a document that says you are giving up the right to sue Ford, Tesla, Mercedes, BMW, whoever, for any injury that you may sustain as a result of the negligent construction of that vehicle, all right? Now, how many people are going to sign that? Most people are never going to sign that, especially if they see it and they actually read it. You're not going to sign that because if such a waiver did exist and you had to sign it in order to purchase a car, what could that cause? What it causes is the following. Okay, first of all, this is very important as to why it is that this waiver, okay, that they want you to sign, dovetails with public policy. First, that waiver would involve much of the public. Why? Because everybody, drives a car. This whole country is, people have 2 and 3 cars. So everybody has a car. So the waiver itself, okay, that they want you to sign, and this is why it's against public policy, involves much of the public. Goes back to that definition, okay? It involves what is necessary, a necessity for many. People have to drive cars, okay? And who is in the driver's seat here? The driver's seat here is a company that is making the cars, all right? You have no control over how the car is made. You are simply the purchaser, right? So if you had to sign a document like that, it could reduce the motivation of a car manufacturer to make a vehicle that's safe, right? So all of the commercials that you see sometimes, or the TV shows you see about, car manufacturers and how vehicles are tested to make sure that they're running correctly, the crash testing with the dummies, and all these things that are done to ensure that when you get in a car, you're getting in a car that is safe, a car that can take a hit at 15, 20 miles an hour, and only X will happen to you, or a little faster, Y would happen to you. All those things are done in order to protect you, the consumer, okay? So it would be against public policy for manufacturers to require you to sign this type of document before purchasing your vehicle, because it contains and it involves a circumstance that relates to much of the public, okay? If this was just a small number of people and a small test car, for example, people making some companies make a test car that is, supposed to do certain things that are, better than other cars, and it's only going to be readily available to, like 10 or 15 people, all right? The government would never make a public policy initiative that relates to that car, because it only concerns a small number of the public, i.e. the 10 or 15 people in the world that are going to buy that car. The government doesn't care. it's like you assume your risk. They tell you up front, this car is a test car, it goes 300 miles an hour, that's on you, okay? That is not something that is going to trigger a public policy initiative, right? So this would, right? Because after a while, car manufacturers, they wouldn't care if the brakes are on tight, if the wheel is all the nuts on the wheel before they send it out are on correctly, if the steering wheel has some shimmy in it, if the seatbelt doesn't work, they wouldn't care because they're saying you've waived their responsibility for anything that might happen to you. So they will have a sloppy construction of motor vehicles after that. Does a waiver that protects a ski resort from liability for negligence and is required of all skiers, will that violate public policy? Okay, well, you have to ask yourself the question here. Does a ski resort, does the fact of skiing involve much of the public? Well, it probably does involve quite a number of people, okay? Because I don't ski, but I'm sure there's a lot of people that do. So it probably would involve a significant number of people. So that would probably violate public policy. For a ski resort, just like Learn to Surf LA, telling you that we're not responsible for anything that happens to you when you go surfing, right? This same situation could occur for a ski resort. Them writing off liability for anything that happens to you might be a problem, right? But is there a difference? Suppose that same resort required a waiver for ski competitions involving superior and professional skiers. Would that violate public policy? Well, again, that's a little different because here the general public is not affected and public policy is probably not violated. Why? Because there's a smaller number of skiers that are considered professional and can ski in high-end ski competitions than there are regular, leisurely people who just go on the ski slopes just for fun. So public policy, a waiver that required ski competitions involving superior and professional skiers, that would probably violate public policy. I mean, that probably would not even trigger public policy because, again, it's just a small number of people that are actually who ski at that professional, high-end level, right? So public policy is not triggered by C. It is triggered by B because, listen, they would say, listen, it's the resort that knows their trails. They know where the trees are. They know where the trails are more difficult and easier. Okay, so they're the ones who have control over where it is that these people are going to actually ski. So if you had a young person, or a little kid, go down the wrong trail because it's not marked properly, he might slam into a tree and get killed, right? They should not be able to write off liability for that because you signed a waiver, because they're in the position to know. However, a professional skier would probably know the courses, know exactly how things are set up, and also would go down the right trail. And if going into, getting ready to run into a tree, can probably avoid that as well. All right. So the question is, what triggers public policy? And the most important thing is, does it involve most of the public? Much of the public. If it does, and it's something that is harmful to them, then a public policy initiative, okay, could probably be written that is designed to help them, okay. And if someone wrote a waiver or required a waiver that absolves this company of any liability for something that could affect the entire country or most of the people in the country, that waiver would be violative or in violation of public policy. So the things to consider when you are doing and looking at waivers are the following. Is the activity essential to the public? So this is how you decide, is the waiver, okay, is a waiver going to be upheld? If, for example, if someone had signed a waiver, they got injured, and they wanted to sue someone in court for it. Some of the things that the court is going to look at and take into consideration are the following as it relates to waivers. Is the activity that is underlying that injury essential to the public? is the agreement, the waiver agreement, was it signed voluntarily? Who are the parties to the agreement? Who are the parties to the agreement? Remember, in contracts, you have to have individuals who have to be situated at a level that is equal, and you can't have an overbearing relationship from one side to the other. Okay, people have to be generally equally situated. Does the agreement, i.e., the waiver, contain ambiguous language? What is the nature of the activity? And what is the relative bargaining power of the two? In other words, when the athlete for St. John's, who just got a scholarship, when he shows up with his mother, okay, to sign a contract to play for St. John's, he's on one side of the table with his mother, and on the other side of the table is St. John's coach, probably the president, probably a lawyer or two, look, you might have a situation that is maybe overbearing. In other words, what is the young man, unless he's a superstar, what leverage does he really have to say, you know what, I don't like this contract, I think the contract should be a little, change a little, little more this way, a little more that way. Does he have any leverage to do that? Does he have any bargaining power? If he or she doesn't, then that is something to take into consideration. And whether or not the waiver is attempting to waive what we call gross negligence or intentional acts. I told you 100 times before, gross negligence, I didn't know that works like that. Look at that. Gross negligence, okay, is the closest that you can come to an intentional act. It's just right there, right before you get into criminality, all right? So that's something to consider. So let's look at these things individually. So is the activity essential to the public? Okay, so generally courts have ruled that waivers that affect the public interest, okay, are invalid. In other words, waivers, when it says that affect the public interest, that are in the public interest and that negatively affect the public interest are invalid, all right? Most courts will not uphold it, all right? So let's look at one of these cases that we have in our handout, okay? So in Cazares versus the University of West Virginia, in that case, and what's important here is where these cases are taking place at. In that case, a student at the University of West Virginia signed a release as a condition for playing in a rugby club. That student sued the institution after being injured during the match. So some student in West Virginia is playing rugby on a team for the school, and he gets injured during a match. But obviously, this student has signed a waiver. All of these cases involve people who signed a waiver, just like a St. John student would sign a waiver for here. The university, so who's he suing? He's suing the university. The university argued, okay, and let's just go back. He's suing the university because he wants to get paid for the injuries that he sustained. What is the university's position? The university is defending the position and saying he should not be able to get paid or be able to sue us because he signed a waiver. Okay, and that waiver, if it's considered valid by this court, okay, this court should, as a result, dismiss his case so that he has no case, right? So the university argued that the rugby, in support of their position, that the rugby club was an extracurricular activity and not a public or essential service, okay? So the university, even though the rugby is being played at their school, is just saying rugby is no big deal, okay? It's just some sport that just gets played at the school and is not a public or it's not a public interest. It's not in the public interest, and it's not an essential service. They're saying it's not an essential service. It's like so what? We offer rugby, so what? It's not that important. Okay. In other words, the university needs to downplay it so that it doesn't rise to the level of something that would violate public policy, i.e., if it violated public policy, a waiver that was in support of that would be invalid. All right. The university, that was their argument. However, the court, in hearing this, said the following. The court said that providing recreational activities were part of the university's educational mission and of its performance of a public service. Okay? Now, the university is arguing rugby is no big deal, we offer it, blah, blah, blah. The court said that's not true. Rugby is important, okay? It is a part of the university's educational mission and the part of the performance of its public service, okay? So the university lost because the court here in West Virginia said that your waiver that you had this person sign that absolves you from liability for an injuries, okay, because you're saying this is not an important event, is invalid. Therefore, the young man is going to be allowed to go around the waiver, notwithstanding the fact that he signed it, and sue the school, right? So that's what happened. So again, is the activity essential to the public? Apparently, in West Virginia, rugby is important to the public. It is something that is in the public interest in West Virginia. The court ruled that providing recreational activities were part of the university's educational mission and of its performance to public service. Okay. Next issue. Consider then, well, you look at this then. Again, it's always important where these cases are being heard, because you have to realize that as a lawyer, everywhere in the country all the courts in the country do not generally look at every case the same way. And if you are a lawyer or a paralegal that is advising a lawyer or giving a lawyer information, you have to know what is the general thinking, the general sense of how certain cases are looked at in the location that you live in, i.e. in the state that you live in. Okay? That's very important. So now we're looking at the state of Massachusetts, okay? So in Sharon versus the city of Massachusetts, okay? I'm going to read it from the document here, then we'll get to what's on the screen. The Massachusetts Supreme Judicial Court upheld a school district's release signed by a student and her father to permit her participation in cheerleading activities. Let's read it again. The Massachusetts Judicial Court upheld a school district's release. The release is the same as the waiver. Okay, it's the same thing here. Signed by a student and her father to permit her to participate in cheerleading activities. So there's a young lady in Massachusetts who attends a university, and she wants to be on the cheerleading squad. Before she gets on the cheerleading squad, she signs a waiver, just like here at St. John's, just like what this other young man did down in West Virginia. So she signs a waiver, right? Obviously, keep reading, the student was injured while participating in cheerleading practice, okay? And so what does she do? She sues the school. She's suing the school, and the university is defending itself and by saying, no, the young lady signed a waiver absolving the school from responsibilities from any injury. So therefore, court, please dismiss the case in our university in our favor. Right. Okay. The court rejected the lawsuit. What did they allege in the lawsuit? The young lady alleged the following. She and her father alleged that the lawsuit was negligent in their hiring and retention of the cheerleading coach. The young lady who was injured tried to say that the university, that was her cause of action. The university was negligent because they should never have hired this coach. And whatever this coach, because it's not clear in the case, whatever this coach did in how he handled the team, he ended up injuring the young lady. That's what she's saying. Okay, what happened here? In reaching its decision, this is the court's decision, the court, after hearing both sides, noted that the student and her father had ample time to read and understand the release, same as a waiver, okay, before signing it. So they said, first of all, the young lady and her dad, they had ample time to read it before they signed it. That's number one. Here's the other thing that's really important. Also, they said that cheerleading activities were not deemed to be compelled, nor were essential, okay? Cheerleading activities were not deemed to be compelled. That means you didn't have to do it, and it's not essential, okay? And that releases, i.e. waivers, are favored as a matter of law in Massachusetts. Okay, so again, here's what we're saying here. They are saying, this court is saying here that cheerleading ain't no big deal. Cheerleading is nothing. It's just some little old sport. They're saying, this court actually said what the university was trying to say, in the first case. What the university was trying to say in the first case. They were trying to argue that the rugby was no big deal, okay? Here you have the court in Massachusetts saying that cheerleading is no big deal. That's the first thing they say. The second thing they say is she didn't have to do it. The third thing they say is that, this is very important, releases, i.e. waivers, are favored as a matter of law in Massachusetts. They're saying in the whole state of Massachusetts, we prefer people to sign waivers, and we respect waivers and the fact that they are actually done. So on the question of the first question that you're looking at, is the activity essential to the public? Okay, a consideration. In Massachusetts, cheerleading is not. But in West Virginia, okay, apparently rugby is, okay? Now, why would something like this happen like that? Well, if you look at the two states, I don't know what goes on in West Virginia. It's just some pretty old, state where probably a lot of country town and colleges that are just basically operating at, at a particular level and enjoy their sports. Massachusetts, home of Harvard, MIT, all these high-end schools, all right? You have a judicial system. A lot of the judges there, the legislators probably come from those same universities. It's not likely that they're going to allow those schools that they probably support, okay, to be sued, all right, by some young lady who got injured doing cheerleading, okay? Because if that happened, it would probably break the backs. Okay, if someone could sue for cheerleading, it would probably fiscally break the backs of